New Jersey is in a fight that could shape the future of short-barreled rifles across America. And if you think this is just another state lawsuit, you may be missing the moment when one of the biggest federal gun laws in history starts getting tested from every side. Quick question before we keep going, are you subscribed yet? Because stories like this move fast, and if you miss one update, you can end up relying on old gun law advice at the worst possible time. Hit subscribe now, because what I'm about to break down could matter a lot more to your rights than most people realize. Here's what just happened. New Jersey is still defending its ban on short-barreled rifles, often called SBRs, while courts and gun rights groups are taking a fresh look at the National Firearms Act, or NFA, after the federal tax on many NFA items was cut to zero starting January 1st, 2026. If you're new to this, an SBR is generally a rifle with a barrel under 16 inches, or sometimes a rifle under a certain overall length. That sounds technical, but the real issue is simple. These are still firearms that many gun owners say are useful for lawful purposes, like home defense, training, and safe handling in tight spaces. Now, this is where it gets interesting. For years, the federal government defended the NFA partly as a tax law. That mattered because the NFA has long imposed a tax and registration system on certain items like suppressors, short-barreled rifles, short-barreled shotguns, and some other weapons. But Congress changed the numbers. The tax for many of those items dropped from $200 to $0. And that opened the door to a huge question. If the tax is now zero, can the government still justify the same registration and approval system the same way it used to? That is not some made-up internet theory. Multiple lawsuits started pushing exactly that argument. Gun rights groups have argued that once the tax is gone, the old constitutional foundation gets weaker, because the law starts looking less like a tax and more like a straight-up registration and control system. That is why people are saying the courts are revisiting the NFA. Not because the whole law vanished overnight, but because the legal argument around it just changed in a big way. But here's the crazy part. Even with the tax at zero, the federal registration and approval rules did not automatically disappear. That's the mistake a lot of people make. They hear zero tax and think free pass. No, that is not what happened. As of now, the federal system still requires approval and registration for the covered items. So if someone hears a headline and rushes out thinking the NFA is dead, that person could be walking straight into serious legal trouble. And that brings us back to New Jersey. In New Jersey, the state ban is even harsher. The problem is not just federal paperwork. New Jersey treats short-barreled rifles as prohibited weapons under its own laws. On top of that, New Jersey guidance has long warned gun owners that what federal law might allow or register can still be illegal under state law. That means even if federal rules soften someday, New Jersey could still say no. Think about how confusing that is for the average gun owner. Imagine you live in a free state. You follow the federal process. You do the form, you wait, you get approved, then you move to New Jersey or travel without understanding the difference. Suddenly, the thing that was legal where you came from may be treated by New Jersey as a criminal offense. That's not just annoying, that's life-changing. Here's the part nobody's talking about enough. New Jersey's fight matters more now because if federal NFA restrictions get weakened in court, states like New Jersey become the next line of defense for gun control supporters. In other words, if the federal wall gets cracks in it, the state wall becomes even more important. So when New Jersey defends its SBR ban, it's not just defending one state statute. It may be trying to preserve a backstop in case the bigger federal system starts losing cases. And there's already a live challenge. Firearms Policy Coalition filed a federal lawsuit against New Jersey's SBR ban in July 2025. The group says the ban violates the Second Amendment and the 14th Amendment. Their basic argument is simple. SBRs are still arms, meaning weapons protected by the Constitution, and the state cannot ban them unless it can show that kind of ban fits America's historical tradition of gun regulation. That standard comes from the Supreme Court's Bruen decision, which changed how gun cases are judged. The plaintiffs in that case pushed for summary judgment in 2026. That means they asked the judge to decide the legal issue without a full trial because they believe the facts already show the law is unconstitutional. That is a big move. It tells you they think New Jersey's position is weak under the current Second Amendment test. If you're finding this helpful, imagine what you'll learn in my next video, where I break down the exact legal difference between federally regulated and state prohibited, because that misunderstanding traps a lot of gun owners. Subscribe so you don't miss it. Now let me explain why the federal side of this story is so important. One of the recent cases people keep talking about is United States versus Rush. In that case, the Seventh Circuit upheld the federal NFA rules involving a short-barreled rifle. The court leaned on older precedent, especially the old Miller case, and also said the record in that case did not show that short-barreled rifles were commonly used by ordinary, law-abiding citizens for lawful purposes like self-defense. The court also stressed that the NFA was a registration and taxation scheme, not a complete ban. At first glance, that sounds bad for gun rights claims involving SBRs. And honestly, for that moment, it was. But wait, there's something even more important. The legal world did not freeze there. After Congress reduced the tax to zero, challengers started arguing that the federal government cannot keep pointing to a tax-based structure the same way it used to. So even if Rush helped the government at one stage, the ground under that argument is shifting. Most people think court cases are only about who wins that day. But the truth is, timing matters. A case decided before a major law change can suddenly look very different after that change. That is exactly why this fight is heating up now. Gun rights groups are saying, you cannot keep the burdens if the supposed tax foundation is gone. On the other side, defenders of the law are saying, a $0 tax is still part of Congress's power, or at least the system can still stand for other reasons. Here's a hypothetical example to explain this. Imagine Congress creates a special tax on owning red bicycles, then builds a whole approval system around it. Years later, Congress says the tax is now $0, but you still have to register your bike, submit paperwork, and wait for permission. A lot of people would ask, if there's no tax left, what exactly is this system resting on now? That's basically the question being raised with the NFA. Now, quick legal note, this is educational information, not legal advice. Always consult an attorney for your specific situation. The New Jersey angle makes this even more dramatic. In many states, if the federal NFA system were ever cut back by the courts, people might gain real access to SBRs, depending on state law. But in New Jersey, there is a separate state barrier. New Jersey law and warnings from New Jersey gun law sources have long treated an SBR as part of the state's prohibited sawed-off shotgun category, and the penalties are not small. We're talking about a third-degree crime with possible prison time and heavy fines. That means New Jersey residents are stuck in a double bind. If federal law says no, they're blocked. If federal law changes, New Jersey can still say no. And that's why this lawsuit is such a big deal. It attacks the state ban directly instead of waiting for the federal NFA to collapse on its own. Here's what most people get wrong. They think this is only about hobby gear or range toys. It's not. The plaintiffs argue that shorter rifles can be easier to control in close spaces, easier to maneuver inside a home, and more useful for lawful defense. Whether you agree with that or not, that is the legal claim. And under modern Second Amendment cases, courts are supposed to ask whether the arm is covered by the text of the Second Amendment and whether the government can point to a strong historical tradition for banning it. This is the part that shocked me. The government often wants to frame SBRs as especially dangerous because they sound scary or because people associate them with old crime movies, but the constitutional test is not supposed to be based on vibes. It's supposed to be based on text, history, and tradition. That means New Jersey has to do more than just say public safety. It has to show the kind of historical support the Supreme Court now demands. Hey, 73% of people watching right now probably aren't subscribed, and that means a lot of viewers will miss the next update when one of these courts drops a ruling that changes the whole conversation. Don't be part of that group. Join the community of gun owners who want straight, understandable legal breakdowns, and hit subscribe right now. Let's talk about what New Jersey is really trying to protect here. First, it wants to keep its own criminal ban alive. That part is obvious. Second, it likely wants to avoid a ruling that says SBRs are protected arms in common use, because that kind of ruling could ripple into other cases. Third, it wants to keep control over the argument that states can still go beyond federal law when they claim public safety concerns. And that third point matters a lot. If a court says, "No, New Jersey, you cannot ban this class of rifle outright," then other state bans on related items could face even more pressure. One ruling can become a tool used in 10 more lawsuits. That is how these fights spread. Now let me break this down in real-life terms. Imagine you are a lawful gun owner in New Jersey who wants a compact rifle for home defense. You are not a criminal. You are not trying to evade the law. You just want something easier to handle in a hallway or small apartment. In many gun owners' minds, that sounds reasonable. But under New Jersey law, that choice can trigger serious criminal consequences. So the lawsuit is asking a very direct question. Can the state completely ban that option for ordinary people? At the same time, federal cases are pushing another direct question. If the tax is zero, why are law-abiding people still being forced into the old NFA framework for these items? That is why the title of this fight is so powerful. New Jersey is not battling in a vacuum. It is fighting while the larger legal map is being redrawn. Don't make this mistake, though. Do not assume that because lawsuits were filed, you can act like the law already changed. It didn't. The safest rule right now is this. If you live in or deal with New Jersey, treat the SBR ban as fully active unless and until a court clearly says otherwise. And even then, make sure you understand exactly what the order covers. A partial win in one court does not mean instant freedom everywhere. Another thing people miss is that the federal government itself has not always taken the same tone in every gun case. In some areas, states like New Jersey are stepping in more aggressively to defend restrictions. That tells you something important. Even if the federal position shifts, anti-gun states may keep pressing forward on their own. So for gun owners, the battle is no longer just Washington versus the Second Amendment. It is also state by state, court by court, and sometimes county by county. And that's why this story matters beyond SBRs. It's a test of how far states can go after Bruen. It's a test of whether the NFA can keep standing the same way after the tax drops to zero. And it's a test of whether courts will finally treat shorter rifles as protected arms instead of just repeating old assumptions. This information could become even more important as more rulings land and more deadlines approach. Subscribe now, because my next video will explain the exact chain reaction that could happen if one federal court strikes down part of the post-zero tax NFA system, and what that could mean for state bans like New Jersey's. So here's the bottom line. New Jersey is trying to hold the line on its SBR ban at the exact moment the federal NFA is facing new pressure after the tax on many covered items dropped to zero. That means this is not a small side issue. It could become one of the clearest examples of how state bans and federal gun law collide in the post-Bruen era. If you take one thing from this video, let it be this. Do not assume a $0 tax means zero legal risk. And do not assume a federal challenge automatically fixes a state ban. Laws move slower than headlines, and if you get ahead of the law, you can pay for it with your freedom. Subscribe, share this with another gun owner, and stay informed, because the people who follow these cases early are usually the ones who avoid the worst mistakes later. And as always, this is simple educational information, not personal legal advice. So talk to a qualified attorney before making any decision about your own firearms.